That you are for the petitioner?
No, I'm for the respondent.
Who is for the petitioner?
Petitioner, in WPL matter, late Mr. Manoj Kumar Sinha used to appear. Now nobody's name is appearing in CNP matter. Now the claimant we had a talk with her and she is ready to come and receive it.
She personally will come.
Yes. This is what we have requested.
Lordship, may I mention on the already given the mentions with
Lok Adalat is tomorrow only.
Yes. So it has to be notified and there.
See, whenever we refer the matter for Lok Adalat, a consent is required. Okay, the check is ready?
No, but as per instructions, yes, it is ready and we had a talk, the officials, they had a talk with the claimant directly. She is ready to come to the court tomorrow and receive the check. If the matter will be notified and referred, otherwise we will.
Okay. Who is the counsel for the petitioner who has expired?
Mr. Manoj Kumar Sinha.
Oh, sorry. What is the case number?
Case number is CNP number 878 of 2023, which is arising out of WPL number 6969 of 2017.
This lady, she's a lady?
Yes.
This lady is the writ petitioner?
Yes.
Okay. Please take down. This is CMP को notify
पर कर देते हैं.
Give the slip.
Yes.
You have mentioned whatever you have said
Yes.
in your slip.
I have simply mentioned that the matter has
You
been
kindly
settled.
put this. The matter has been settled out of court. The petitioner, the writ petitioner lady is ready to come to the court tomorrow to receive the settled amount. इतना आप slip पे लिख दीजिए. इसको notify करा.
4 बजे.
हाँ 4 बजे करा दीजिए.
I mentioned from this list serial number 9 we have identified fresh vacat number in this case. I have received the vacat number, it will file on Monday. Therefore, I am praying only for not today, it may come next week. Subject to praying. Serial number 9.
9 को simplicity not today कर दीजिए.
Lordship, this is assigned matter, Lordship. 2 times already heard, but very few times, 1 or 2 minutes like this. And curiosity of the time. This is the assigned matter, so I want to dispose of.
Is it on the board?
Out of this.
You have given the slip?
Yes.
Okay. You have given your date?
No, it's still not taken the
Next week.
Next week.
much of
You are for the petitioner?
petitioners.
Who is for the other side?
Other side, the Lohardaga, the Lohardaga municipality.
But somebody should be there, no? Some council should be there for Lohardaga municipality.
I will inform.
Final disposal item 1, WPS 6497 of 2016.
Lordship, supplementary counter affidavit is ready in this matter. It could not be filed because it had been affidavit yesterday. So therefore, if the Lordship permits, it will be filed by today.
Okay. Would you like to respond to that? Have you given him a copy?
Lordship, I noticed. कॉपी दिया गया लेकिन गलती से किसी और सर्विस पर साथ में दे दिया गया.
आप इनको देंगे ना?
हाँ, दे दें.
You will do it during the course of the day?
Yes,
You will give him a copy also during the
Yes.
course of the day?
Yes.
WPS number 6497 of 2016. Counsel for the parties are present. Counsel for the respondents seek permission to file supplementary counter affidavit. The counsel for the respondents is permitted to file supplementary counter affidavit during the course of the day. Counsel for the petitioner submits that, if so advised, the petitioner may respond to the supplementary counter affidavit. Post this case on 5th of January 23. The reply to the supplementary counter affidavit be filed by 22nd of December. the parties to file short synopsis of arguments, list of
I
dates.
already.
After seeing the supplementary counter affidavit, you may have to file something. The councils shall file the list of dates, synopsis of arguments, and also the judgments which they seek to rely upon, much before the next date of hearing.
Item 2, WPS 5107 of 2017.
Yes.
The issue is regarding absorption of post facto absorption or regularization of a college of a lecturer of a constituent college. And in the last week when the matter was taken up, there was a query of this honorable court with regard to the 1977 statutes, which changes the required qualification. Earlier it was second class and then higher second class. And that 77 statute, which is also there in the compilation manual of university laws, I have given a copy of that. And apart from that, there was another query of this honorable court with regard to high second class prescription. That we could gather from certain statutes. It mentions that it will be the midpoint of the total. It is from 46
range.
to 50 midpoint. In between
Total
40,
range.
Yes, 46 to 50.
From where do you get this?
That is there in the statute itself.
Because
I'm just referring to that.
yes, where is that?
Yes, I'm just referring to that. If that is one statute which starts from page 140, there this description is given, which is basically a revised statute, but it, so far as for this purpose, this midpoint.
114.
Yes.
Enrollment and degrees.
If 140, that is part 2.
Part 2, 100.
Part 2 contains the statutes.
Yes. 1983.
Yes, 1983.
Where does it say?
Yes, I'll just. That is page 116. Page 116. Just in the middle portion, there is one in bold captions, lecturer in education, just above that. Serial 2 is there, Roman 3. College lecturer heading is there. Just after Roman 3, serial 2 is there. That mentions have persons having secured marks more than, it is English 2, persons having secured marks more than the midpoint of the prescribed minimum marks for passing an examination in the second division, and the prescribed minimum marks of passing an examination in the first division by a university shall be deemed to have passed that examination in the high secondary class. Apart from this, there is nowhere else I could find out. This is one. This specification I add.
Working on the Justice Agrawal Commission, the SC Agrawal Commission, this issue has been raised by them. And look to it.
He was governed by 77 statute.
Yes, that aspect has been raised. What constitutes higher second division? Exactly, it has been given at page 41, the second flag. At page 34, that says basic minimum qualification. Page 40. First paragraph is at page 40. High second class would be securing 52.5% or more marks.
This is basically mentioning about general connotation,
Yes.
but in the statute of 1983, it has been mentioned to be the midway. Prior to that, there is no such statute.
High second class that is prescribed, but cutoff that is also dead. That cutoff 52.5.
That is in general connotation. Agarwal Commission report
Yes.
could be binding on those colleges which are covered under the Agarwal Commission report. It is not a precedent for a
No,
court.
just to be checked.
It has only said that by general connotation, it has to be taken to be the midpoint.
Yes.
Right.
That
But this statute which he has produced, revised statute in respect of qualification of teachers of universities, this is revised in the year 1983. Have you seen that?
yes, I have seen it. That is, even it says 52.5 midpoint.
If this honorable court is inquiring about the cut-off date, since when it has come, that will be clear from one of the statutes which is part of the paper book,
Yes.
page 139.
Okay. 139.
139. I'm referring to the amended date.
Yes.
139. This is part of a statute of time-bound promotion. Page 139. There is
I'm
a
not able to figure out whether it is amended petition or amended petitions. Page number
139. I'm referring to the amended date petition.
Yes.
There maybe I do not know the
Yes, it is
double
the
page
139.
reference.
Yes.
Page 139, there in the middle there is a note. This is a statute, university statute. It is in bold letter note. As per the relevant statutes, the prescribed minimum qualifications for lecturers in arts, science, commerce, and education for the purpose of clause A above. With regard to clause A is above, clause qualification. Pre-17-1977, second class master degree in the subject. From 1777, a first or high second class relaxed to be appear second class in case of SC/ST master degree or equivalent degree of a foreign university in the subject concerned with consistently good academic record, followed with PhD or MPhil degree for education level plus for basic science teachers relating to qualifications included from 1777. So from this it appears that prior to 1777 the requirement was second class master degree, and since from 1777 it has been modified
To high second class master.
high second.
But high second class master degree was defined when? Because your statute, under whatever you have said, in your statute, you have produced that statute, no? It does not give any definition of high second class, does it? 77 statute is not giving any definition of high second class. It talks about first or high second class master's degree, right? But it is not mentioning anything about what is high second class. Is it mentioning? It is not mentioning, right? But in the statute that you have produced, that is of the year 1983, right? There they have given the qualifications. And here there is an explanation as to what would be the high second class and how, because now they must have realized that that is creating a problem. There is a confusion. How do you get high second class?
Therefore, it has been clarified.
Therefore, this has been introduced and put in clause 2.
Yes.
This is in 1983. That is post your appointment. So therefore, I wanted to know from them, that is why I have drawn an order to that effect, as to from where do you get high second class. Now he has answered it by referring to 1983 statute.
Yes.
Now you refer to some statute, some provision prior to 1977. The advertisement, you see, normally the advertisement should give the percentage marks.
Yes, that is
right.
that generally.
The advertisement is high second class.
Yes, that is.
So
But
either
what-
you see, I will give you more opportunity to
Why not?
produce it,
Right.
because if you are not able to produce it, that advantage he should get.
I'm getting what is it. Yes.
He could not get what I wanted to know on the last time. I think perhaps by now he must have got it.
No, I have understood. If the things are vague,
Yes.
things should shift in the favor.
Certainly, if it is vague
Vague then.
and clarified later on,
Yes.
then that cannot be put to his disadvantages.
But one paragraph is from the report. If I am
No, Agarwal Commission
what is
report.
referring to? What's one paragraph?
No,
Just-
you see, we cannot refer to the report. That is not a statute, nor it is a binding precedent on us. Even if it is by a retired Supreme Court judge or whosoever, it's a report, and
It's
it will only.
adopted.
We will not go.
Paragraph,
We will go by the statutes,
That's-
by the judgments pronounced by the High Court and Supreme Court on the specific point to that.
But still, I was requesting one paragraph. If my not
Which
be-
paragraph do you want?
Yes, page 39. Just one paragraph. Because I have-
Your authorities will be in a position. Mr. Mehta is there, he must be knowing. Do you know Mr. Mehta? From where do you get, since when do you get this high second class?
Second class range
Yes.
is between 45% to 60%.
Fair enough.
Right? There's a difference of 15%.
That's right.
So what they did was, they took the mid figure,
Who?
7.5.
Who did it?
The statutes, the subsequent statutes that have.
83.
Yes.
He was appointed in 77.
So what happens is 45 plus 7.5 is 52.5. That is what was clarified later on.
It is, you see, it is something
not
which is,
clarification.
so therefore, a new thing is being introduced, right? Maybe by way of clarification or whatever. But this particular person has been duly, completing all the process, has been duly inducted. and his candidature has been rejected only on the ground that he did not have high second class qualification. So the point is, from where do you get it? And we have seen the advertisement also. It is not mentioning any percentage. So a person who has been inducted, all scrutiny has been done. Can he be now deprived? If there was a statute, then of course, then we would have seen, right? And his status has been scrutinized multiple times. No suppression on his part. So this advantage he should get.
52.5 introduced for the first time in 83.
Is that correct?
Yes, it is correct. Before that, the statutes were silent on that.
So if it is silent, then it should go to his advantage.
So then the question would arise, what would be the
High means what? Even
high-
0.1% is high. Who bothers about it? If there is vagueness in your advertisement, and if there is vagueness in your statute, and then you scrutinize his entire academic records and give him appointment, and at the fag end, after his retirement or at the time of his retirement, can you deny him the claim which he has that he was duly appointed in the year 1977? It's too harsh on him.
he was probably never regularized. That is the issue.
That is the issue, and that is the solitary reason for not regularizing him, that he did not have a higher second class. So that is why I am recalling upon the respondents time and again. I will give you one more opportunity. You file an affidavit. If you are able to, this
There is
statute I will refer.
Something is there in terms of the statute, that's why I was pressing this paragraph. I will have to just find out.
I want to see the statute. I will
Yes.
not go by any commission report. Please
No,
don't ask
but-
me to do that. I will look at it, but that is
Yes,
not
yes, that I
binding.
understand. That I understand that what is binding is the statute of conservative
Yes.
regulations. Page 39 I was pressing.
Yes.
My lord is what?
Hmm.
The expression, I am reading
Yes,
the
please.
expression consistently good academic record is not defined or explained in 78 statute. The said expression is also used in Annexure A to the order dated January 24, 1976 passed by Government of Bihar. And in the explanation it is indicated as to how the expression is to be understood for the purpose of applying the minimum qualification prescribed in the said annexure. The said order of the Government of Bihar dated so and so and Annexure A thereto as amended by order dated so and so were sent to all universities in the state of Bihar and were before the Senate of the university when it framed the 78 statute because the minimum educational qualification for the post of lecturer as prescribed in 1978 statute are practically the same as those prescribed in Annexure A to the order dated January 24, 1976. It can therefore be reasonably inferred that expression consistently with the current record statute has the same connotation as given in the expression explanation A to the order so and so as amended by order dated so and so. So I will go for a specific that what higher second class at that point of time, and then second issue will come into picture then, because 83, even in 83 it was made applicable as my friend has pointed out for 77. Why this issue has come up for regularization at this stage after retirement? Why he has chosen to go for regularization or making a
By
prayer?
virtue of orders of the court. The order impugned has been passed by virtue of orders of the court.
Yes.
Then
So
any
83
delay, laches, all is gone.
83, that will be a issue that will fall for my last consideration. That 83 he keeps on waiting. At least at that point of time it was clarified and his services were not
You
regularized.
see, he was duly appointed. You say that his appointment itself was illegal in 77. That is your ground. A person who is duly appointed, who is working by virtue of some statute, he will start challenging his own appointment. Do you expect that? Is it an action of a prudent man? A person who is already appointed, who is working by virtue of a
But service
subsequent.
was never regularized.
That is why their orders have been passed to consider his case for regularization, and the solitary ground is that he did not have a second class, high second class. That is the only ground.
So then give us 2 weeks time.
Mr. Banerjee, for the now you have heard the discussions, right? Last order was also drawn. to give fair opportunity to the respondents, you file a supplementary affidavit. Possible?
Yes.
Please do that, and then you
Yes,
respond. That would
so
be
that
better,
should
right?
be
You
very
annex
clear.
the copy of 77 statute, you annex the copy of this 83, right? And then you can simply say that to the best of your knowledge, there is no other statute, because Mr. Mehta has already said that there was. You can annex the advertisement also. Advertisement was just.
Yes, I have enclosed to my report last page, but it is not very clear, but it says high second class.
It is there, I will bring it.
You bring it on
Yes,
record.
it was there with the previous records, I will bring it.
So you can simply say that at the time of your appointment there was no clarity. Then we'll see what is to be
Yes,
done.
yes.
And apart
To
from that,
assist my body has taken.
To help the litigants.
Yes, yes. I will not be averse. I am not resisting the.
and Mr.
What is
Pallab, Mr. Pallab may also examine the impact of taking over of a college as a constitutional
Certainly he will
college.
examine, he will respond to your affidavit.
Because the college was admitted
Now it
and
has-
it was taken under the control of the university by virtue of section 72
You,
of the
whatever
university.
you want to say, Mr. Banerjee, you put it in your, don't make it bulky, right?
These are there in the mandate petition, which I am submitting.
You can simply say, basically now entire
has
argument will
been brought.
boil down to this, and after the college was taken over, whether any such objection can be raised. These are the
Yes.
two major issues.
Yes, yes.
You
Because-
just cull it out in your supplementary affidavit, bring these documents on record, and then let him respond. Because after all, it's the order of the Honorable Chancellor. We have to take care of that. They should be given a fair opportunity to respond.
And one more thing, Mr. Pallab examined. At one point of time in this read, they filed an affidavit from the office of the Honorable Chancellor that we have no role to play in this matter.
You
It
see,
is up to the
affidavit
university.
will not decide. It is the impugned order which will decide.
Yes.
So this is the issue in short.
My lord has carved out that what I understand that if a statute is vague, equity will come into play. That's one line what I
Yes.
have understood.
Then it will be easy for me to
Yes.
pass an order in equity.
Yes, inequity, that is what is.
So things should be very, very
Instead of
clear.
defining and redefining higher second class, it will go vague and that how the equity will come into play.
And
That's what I am understanding.
Coupled with the attending facts about taking over the college, about fixation of the
We are,
PSK.
all attending facts will be taken care of, but if this comes into picture, everything will be very, very clear.
And there are then the petitioner is also referring to parity. There are certain orders which are already on record, wherein persons similarly placed employees of Ranchi University, they have been given the benefits of the subsequent pay revisions as well as retirement benefits.
They have been regularized also?
Yes, in pursuance of order of this court.
No, they have been regularized in spite of having lower second class.
Lower second class, that is not, but for other reasons.
That is the clinching issue, Mr. Banerjee. Please don't divert from the main issue.
And one judgment is there of
Mr. Banerjee, you have very, very good and good cases in your hand. Please focus on the issue, right?
Use the optic.
No, he generally has very good briefs.
Research.
Very good briefs he has, but he need to articulate it more. Look here, counsel for the parties are present. The learned counsel for the petitioner has referred to the statute dated 12/12/1983 to submit that under to submit that under clause 2 under clause 3 within bracket 2 दोनों English होगा English 3 and English 2 there is a specific provision regarding higher second class in as much as it has been prescribed that persons having secured marks more than the midpoint of the prescribed minimum marks for passing an examination in the second division and prescribed minimum marks of passing an examination in the first division by a university shall be deemed to have passed that examination in higher second class. The learned counsel has submitted that the petitioner was appointed as back as in the year 1977, he has produced the statute, as back as in the year 1977, and he has not been able to lay his hand on any such similar provision under the statute of 1977. Considering the point involved in the present case, the counsel for the petitioner is permitted to file a supplementary affidavit bringing on record the relevant statute and the points he wants to argue in support of his case. The affidavit be filed within a period of 1 week. Be filed by 22nd.
Petitioner is residing in his native village in Bihar. He is not well.
If he is not well, in a writ petition, you can ask somebody else his.
It is now allowed that notary public they get it done.
I don't know. Get the needful done by 22nd. By 22nd, the affidavit, the counter affidavit to the supplementary affidavit of the petitioner be filed by 5th.
More valid because there's a vacation.
Your governor is in vacation.
I am.
So what? You have to just forward it to him. He has his entire
My
secretariat.
engagement is all for the expert reason, not for the reason that government
Okay.
itself has to act.
All right. 5th, then instead of 5th, let it be by 12th.
Yes, yes.
Post this case under the same heading on 19th.
Grateful. Okay.
Pattern 3, WPS 6351 of 2018.
Yes, petitioner.
As per the case, that's now filed the list of dates.
Okay. What
Under
is your
this
case?
petition, the petitioner has two-fold merits. First is to grant him the back wages arrears of salary for the intervening period of 10 years. And second is to grant him promotion since his batchmates who have already been considered, but he has not been granted the same from the date when his juniors have been considered. These two pairs are there.
Just a moment. You are seeking the reinstatement.
No, back wages.
Back wages from
From
2/3/2008.
yes,
To?
12/3/2000, sorry, 18 it is, by mistake. It is 18.
Okay.
Second is to consider the case of the petitioner for promotion in view of the fact that batchmates of the petitioner were promoted with effect from 2016. And first is the batchmate of the.
Any junior to you has been promoted.
First of all.
Batchmate being promoted is not the same thing as junior being promoted.
No, this is a different. First, I will have to place the fact mallet for present mallet. In this case, what has happened is the petitioner was appointed in the year 1990 on the post of police constable. Thereafter, on
Let us see the list of dates.
Yes.
1990.
He was appointed on the post of constable.
1990. Okay. All
Yes.
right. Okay.
On
Then
6/2/2006, while posted in Chaivasa, there was an allegation of involvement of the petitioner in making forged home guard certificate, as well as interpolation in the master chart of the candidate selected in pursuance to advertisement number 1/2008. Thereafter, an FIR was lodged against the petitioner against the under section 419, 420, 467, 468, 471, 72, 73, 120B of the IPC. Thereafter, charges were framed against the petitioner and so-called notice was issued to the departmental proceeding was subsequently.
is it a defective petition?
No.
Okay. This is the third final disposal.
Yes.
Okay. Please carry on.
On
Yes.
31/10/2006, the matter was inquired. The inquiry officer submitted his report holding the petition guilty. 31/1/2008, order of dismissal was from service was inflicted upon the petitioner. 35/9, preferred appeal mallet, which was also dismissed. And being a writ mallet, thereafter the petitioner preferred a writ petition before this honorable court by WPS number 3506 of 2009. Now, during the pendency of this writ petition matter, the criminal case which was instituted against the petitioner
he was honorably acquitted in that manner. 5-10-17, the aforesaid repetition was allowed. And it was matter was remitted back to the respondents to consider the case of the petitioner quantum of punishment in accordance with law and pass appropriate order on the ground of doctrine of parity as that of his co-delinquent Major Ramakant Prasad within a period of 12 weeks. This was the order. 13/3/2018. He was reinstated.
What happened to this Mr. Major Ramakant
Yes,
Prasad?
this. What has happened? These two persons were found involved. Major Ramakant Prasad and this petitioner.
Okay.
Major Ramakant Prasad, he was not dismissed. He was inflicted with a lesser punishment only of a stoppage of increment of 2 years.
Okay.
And this petitioner, being a constable, since he was a basic feeder post, he was made a scapegoat and he was dismissed from service outrightly.
Okay. So
thereafter, considering this aspect of the case, the doctrine of parity applies between these two because they are co-delinquents and same set of charges is there against both of them.
that's right.
Therefore, he shall be reinstated and he shall be inflicted with the same punishment.
What happened thereafter?
Now, thereafter, I have been reinstated and same punishment which was inflicted upon Ramakant Prasad way back in 2008, the same has been imposed upon me, that is stoppage of increment for 2 years.
Okay.
So now my claim is that since this order has come after the Honorable High Court held, yes, this is a case where doctrine of parity has been declined, this person has been deprived of his legitimate rights. Now the
Back wages were given to that person?
he was
When we
not
talk
dismissed.
about-
He was not dismissed, my lord. He was in service all throughout.
All right. So there was no question of any back wages.
No,
he was not suspended also.
No, he was only inflicted with a lesser punishment. That to the minimum punishment in
Okay. Then
now my case is, my lord, he thereafter made a representation for releasing the areas of salary and back wages, my lord, which has been declined on the basis of no work movement. This is the stand of the respondents. And
you have not been exonerated, have you been? It is not a case where you have been exonerated.
I have been exonerated in the criminal trial, my lord.
You have not been exonerated
I
in the disciplinary proceedings.
Yes,
Some punishment has been inflicted
some
on you.
punishment has been.
So you were guilty in the departmental proceeding. It was only that some kind of a different punishment was granted.
Excessive punishment.
Whatever, we do not know.
Dismissal from service. This is a major punishment, my lord, as per police manual, and this is the maximum which.
That's right.
which
So you want back wages?
my claim is that, my lord, since if my lord peruses the Honorable High Court's order within the first round of litigation, there it has been categorically held that the stand of the respondents is illegal and therefore this punishment order does not deserve to be inflicted upon the petitioner. It does not deserve to be dismissed from service because of the doctrine of parity. Now my claim is that the doctrine of parity comes into play, then it is for all purpose. It is not only for punishment, it is for all purpose since Ramakant Prasad was the same, he was the main accused of the, because my ladyship, a mere constable cannot interpolate the master chart of the
We
candidates.
do not know. A mere person can do what not.
But Ramakant Prasad was kept in service, he withdraw all the salary, all the perks, all the allowances.
So therefore, you are seeking parity that you should be put at par with Ramakant Prasad.
Yes, on the basis of area of salary. And second, my lord, this promotion, I have been.
Promotion is a distinct cause of action. How do you club this departmental proceeding with a promotion case?
Because after the statement, my lord.
It is not automatic, is it? It is a distinct cause of action. You may approach them for whatever grievance you have regarding promotion. It's a different, absolutely distinct cause of action.
Only
Did you approach them for promotion?
Yes, my lord, I have written the representation and they have denied me, they have considered me fresh appointee from the date of reinstatement. That is my case. Why I should be considered as fresh appointee when I was, I am constable since 1990.
Where is the impugned order where they consider you as a fresh appointee? You have filed your counter affidavit?
Yes.
Okay. Has he been treated as a fresh appointee? Let us see.
Annexure 2, my lord.
Impugned order.
Annexure 2. Impugned is Annexure 3, my lord.
Annexure 3.
Yes.
Just come to the operative portion. Yes.
First page, third paragraph. उक्त न्यायाधीश के प्रति के साथ बर्खास्त आरक्षी सरफुद्दीन के द्वारा एक आवेदन अथवा हस्ताक्षरी के कार्यालय में दिनांक 13/10/17 को समर्पित कर माननीय उच्च न्यायालय के पारित उक्त न्यायाधीश का अनुपालन हेतु अनुरोध किया गया। उक्त न्यायाधीश के अनुपालन हेतु इस कार्यालय के पत्रांक इतना दिनांक 12/1/18 के द्वारा उक्त बर्खास्त आरक्षी को चाईबासा देवघर जिला बल में नियुक्ति हेतु पुलिस महानिरीक्षक झारखंड के मार्गदर्शन की मांग की गई। जिस पर पुलिस महानिरीक्षक कार्मिक झारखंड राज्य के कार्यालय ज्ञापन लिखना 13/2/18 द्वारा उक्त बर्खास्त आरक्षी को भौतिक रूप से देवघर जिला बल में योगदान स्वीकृत कराने हेतु जिलादेश निर्गत करते हुए आवश्यक कार्रवाई करने का निर्देश दिया गया। तत्पश्चात माननीय उच्च न्यायालय द्वारा पारित उक्त आदेश एवं पुलिस मुख्यालय प्राप्त किया निर्देश के आलोक में बर्खास्त आरक्षी 574 मोहम्मद सरफुद्दीन तत्कालीन चाईबासा संप्रति देवघर जिला बल को पश्चिमी सिंहभूम जिलादेश संख्या 822/18 के द्वारा तत्काल प्रभाव दिनांक 13/2/18 से सेवा में वापस लेते हुए पूर्व पदस्थापित देवघर जिला बल में आरक्षी के पद पर योगदान करने का आदेश दिया गया तथा चाईबासा जिला विभागीय कार्रवाई 13 विरुद्ध अपचारी रमाकांत प्रसाद के विरुद्ध पारित न्यायालय के समतुल्य आरक्षी सरफुद्दीन को भी 2 वर्षों का वेतन वृद्धि का समर्पण जो 3 कालांक के समतुल्य होगा करते हुए पुलिस अधीक्षक देवघर को जिला बल के प्रति अनुक्रमिक जिलादेश अंकित कर अग्रतर कार्रवाई हेतु भेजी गई। विदित हो कि पुलिस अधीक्षक देवघर के द्वारा पत्रांक 12/4/18 के द्वारा बर्खास्त आरक्षी सरफुद्दीन की सेवा वापस लिए जाने संबंधी पश्चिमी सिंहभूम जिलादेश संख्या देवघर जिला भर में अनुक्रमिक जिलादेश संख्या अंकित कर उसे योगदान की तिथि दिनांक 18/3/18 से देवघर जिला संख्या 12/21/18 के द्वारा आरक्षी के पद पर योगदान कराकर पीतलांग 491 आवंटित किया गया है तथा पीतलांग इज द ब्रास नंबर फ्रेश ब्रास नंबर विच इज अलॉटेड टू अ फ्रेश कांस्टेबल मैडम तथा दिनांक 16/3/18
No, it is, you are misreading it. You see, there is no dispute regarding continuity of service. Is there any dispute regarding? There is no dispute regarding. You are reading it against yourself.
Yes.
You are being too careful in reading it.
My lord, and this
You are misreading it.
This is in my,
That much we can say. You can also say
this is
it's a
in my
misreading of
rejoinder
power.
also that the persons who were with me in 1990 they have been promoted on the post of ASI with effect from 2016.
You can't dodge a question, right? You just now said that you have been given fresh appointment, which is not correct.
Fresh Pitalam, this is my lord.
If they give you something, you see, your number might have been allotted to somebody else. How does that make a difference? Your allocation of your number, is it an allocation of your seniority number? No,
Then,
it is just a number.
my lord, then promotion aspect, my lord, I am not basing that, my lord. I am on areas of salary, my lord. Since this Ramakant Prasad enjoyed all together for 10 years, my lord, and I was inflicted with punishment or dismissal kept illegally out for 10 years, my lord. Therefore, and since it has been held that dismissal order is illegal, and therefore I am entitled for the back wages, my lord.
That's all. What do you have to say?
So, as for the counter, it has been reinstated following the order of the Honorable Court.
That's right.
And then, my lord, for the intervening period, no work, no pay has been given.
No work, no pay principle applies where a person does not wish to work, despite being. So this no work, no pay rule does not apply in this case.
WPS number 6351 of 2018 heard the learned counsel for the parties. This writ petition has been filed for the following relief. At the outset, counsel for the after some argument, the learned counsel for the petitioner has submitted that he will confine this writ petition only to the extent it relates to denial of back wages for the period from 2/3/2008 to 12/3/2018, and so far as his claim for promotion is concerned, the right may be reserved with him to take appropriate steps in accordance with law. Considering the submissions, the writ petition is confined to the prayer of the petitioner in relation to back wages for the period 2/3/2008 to 12/3/2018, and with the aforesaid liberty to the petitioner to raise his grievance in connection with his promotion in accordance with law. The learned counsel for the petitioner. No, it is not in dispute. These facts are not in dispute?
No.
It is not in dispute that the petitioner was appointed as constable in the year 1990. Sometimes in the full stop, sometimes on 6/2/2006, one criminal case was lodged against the petitioner alleging making forged home guard certificate as well as interpolation in the master chart of the candidate selected pursuant to advertisement number 1 of 2008. The co-delinquent के against में भी criminal case हुआ था.
Same.
The FIR was lodged under section 419, 420, 467, 468, 471, 472, 473 and 120 within bracket B of the Indian Penal Code. The charges were framed against the petitioner in the criminal case, and simultaneously show cause notice was issued to the petitioner, and departmental proceeding was initiated by letter dated 6/2/2006. Upon inquiry, the petitioner was found guilty and was dismissed from service on 31/1/2008. Against this, the petitioner filed appeal, and the appeal was dismissed by the order dated 30/5/2009. Consequently, the petitioner challenged the order of dismissal in WPS number 3506 of 2009, and during the pendency of the writ petition, the petitioner was acquitted in a criminal case, while judgment dated 30/5/2016. The writ petition was disposed of by the order dated 5/10/2017. And the matter was remitted back to the respondents to consider the case of the petitioner on the quantum of punishment in accordance with law, and to pass appropriate order taking into consideration the doctrine of parity with that of the co-delinquent Major Ramakant Prasad within a period of 12 weeks from the date of receipt of production of a copy of the order. The operative portion of the judgment passed in WPS number 3506 of 2009, dated 5/10/2017, is quoted as under. Para number 8 and 9 को quote कर दीजिएगा at page number 28. Thereafter, by memo number 779, dated 13/3/2018, issued by the Superintendent of Police Chaibasa, the petitioner was reinstated in service with immediate effect on the post of constable, and was inflicted the same punishment as that of the co-delinquent, namely Major Ramakant Prasad, that is forfeiture of annual increment for 2 years, which will be equivalent to 3 black marks. And by another order contained in memo number 1368, dated 23/5/2018, the salary for the intervening period was forfeited on the ground of no work, no pay, and further that the said duration is to be treated as extraordinary leave. Is that correct? is to be treated as extraordinary leave. The petitioner has challenged the order dated 23/5/2018, whereby the arrears of salary has been denied to the petitioner. उसका order दिखाइए co-delinquent का.
उसका डिपार्टमेंटल प्रोसीडिंग
Certainly.
that has come in the requisition he has been rejected.
पैरिटी चाहिए लेकिन उसका ऑर्डर नहीं लगाएंगे.
वो तो आया हुआ है उसी के बेसिस पे तो ये रेट अलाउ हुआ है मैम. सॉरी.
He was not under suspension.
No, he was altogether working for the police department.
The learned counsel for the petitioner has submitted that since there was a direction that there would be parity between the petitioner and the co-delinquent, namely Major Ramakant Prasad, therefore the petitioner should be put at par with that of Major Ramakant Prasad, in as much as Major Ramakant Prasad was throughout given the salary. However, during the course of hearing, it is not in dispute that Major Ramakant Prasad was working with the department, and so far as the petitioner is concerned, on account of his dismissal, the petitioner remained out of service. The learned counsel for the respondents has submitted that the authorities have rightly denied has submitted that the petitioner that in the matter of grant of wages for the intervening period, the impugned order does not call for any interference, in as much as the petitioner did not discharge any work during this period, and the fact remains that petitioner was not fully exonerated in the departmental proceeding. He was found guilty, but so far as the punishment is concerned, the same was remanded for consideration on the ground of parity. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner had faced a criminal case and was dismissed from service in the departmental proceeding. However, subsequently, the petitioner was acquitted in the criminal case, and in the meantime, the co-delinquent was awarded the punishment of stoppage forfeiture of annual increment for 2 years, which will be equivalent to 3 black marks. Consequently, in the writ petition being WPS number 3506 of 2009, where the petitioner had challenged the order of dismissal, the writ court recorded a finding in para 7 that the court was of considered view that there was no procedural irregularity in the conduct of the departmental proceeding from the date of its initiation till its culmination, but the case of the petitioner needed interference on the ground that the petitioner was inflicted with punishment of dismissal from service, whereas the co-delinquent Major Ramakant Prasad was inflicted with lesser punishment, that is stoppage of increment for 2 years, which was equivalent to 3 black marks. And therefore, the court was of the view that the petitioner's case needs reconsideration on the ground of doctrine of parity. This court finds that the learned writ court had interfered only with the quantum of punishment and had directed the authorities to take fresh decision regarding the quantum of punishment, and consequently the authorities have given the same punishment to the petitioner as that of the co-delinquent Major Ramakant Prasad. So far as the back wages is concerned, the authorities have denied back wages to the petitioner on account of no work, no pay. The fact remains that the petitioner was not exonerated from the departmental proceeding. The respondents were within their right to consider the consequential relief to the petitioner. The fact remains that the petitioner remained away from the on account of dismissal of the on account of the order of dismissal of the petitioner. The petitioner did not discharge any duty, but so far as the co-delinquent Major Ramakant Prasad is concerned, he was working with the department. In such circumstances, the respondents were the respondents were under a duty to give wages to Major Ramakant Prasad. This court is of the considered view that in the matter of back wages arising out of the subsequent order passed by the respondents, the respondents have exercised sound discretion to deny wages to the petitioner, and such order does not call for any interference under Article 226 of the Constitution of India. Consequently, the present writ petition is dismissed.
For orders to defect item 4, CMP 1077 of 2022.
There are some issues existing any working time to use it. Whether one petition has to be filed.
Counsel for the petitioner prays for and is allowed time till 22nd of December 2022 to remove the surviving defects preemptory. If the defects are removed within the stipulated time, post this case under appropriate heading on 5th of January. It's a preemptory time.
Yes.
Item 5, CMP 390 of 2023.
If there are some defects, 2 weeks time may be allowed for removing all.
We have allowed this earlier.
No.
Okay. Same order. Till 22nd, it's preemptory.
Lots.
For orders, item 6, CMP 250 of 2019.
In this case, IU number 2333 and IU number 336 have to be decided. In the midway, my lord had directed them to file a counter affidavit. They got it filed on 4/4/12/23. We have prepared our rejoinder, but could not file it.
CMP number 250 of 2019. Counsel for the parties are present. Counsel for the petitioner prays for and is allowed time till 22nd of December, 21st December.
We get it ready, I can hand over it today itself.
I do not know, you should have done it till 21st of December. कैलेंडर नहीं है यहाँ पर। ये 24 का कैलेंडर लगा
वो
दिया,
वाला।
23 का कैलेंडर गायब।
Thanks for the second. वो 20
ये तो वो लोअर कोर्ट का कैलेंडर है।
ये 23 का है.
The lordship will be the last calendar.
Yes. 15 तक कर देंगे आप भाई?
हम तो कल ही कर देंगे
Rejoinder.
सैटरडे
by 11th of December. Post on 15th. और इसमें ये ऑर्डर्स में क्यों लगा? Why is
ऑर्डर्स में
it?
2 आइए हैं, उसी का कंसोलिडेटेड काउंटर इन लोगों ने दिया।
What is the IE about?
Last order था अनुजा की reply फाइल करना।
What is the IE about?
For substitution and correction of provision, they are subject to objection on the other side, and that I have raised the maintenance issue itself.
Okay.
So I have filed that.
It is
Now
not
they want to-
maintainable.
No, it is not. According to my provision of CPC is there, but therefore.
Okay.
If
Which
you want to
provision have
find
they
it-
invoked?
Yes, sir.
Which provision? You have raised that point in your reply.
Yes, yes, I have. It is not maintainable.
नॉट मेंटेनेबल।
Not maintainable. Yes, I can really. आप reply file करना चलो, otherwise I can address the court. Your lordship, the fact of this case is like that, no? The first appeal was dismissed. Your lordship may kindly have the order before the lordship the dismissal order. 23rd October.
Okay.
23rd of January 2019 order.
Okay. What is it?
Yes. No.
Yes, please read it. पढ़िए क्या लंबा चौड़ा ऑर्डर है?
नहीं, बहुत छोटा सा है, लीजिए ना।
हाँ।
Please. 23rd January 2019 का order लिखिए। I think it should be the last two. Nobody appears on behalf of appellant. Counsel for the respondent submits that the supplementary affidavit has been filed in this case as that was on March 10/4/2018, intimating that the sole appellant has expired. But till date, no application for substitution has been filed, and accordingly the appeal law has availed. Considering the submissions met, it appears that on 10/4/2018 an affidavit as filed with the respondent intimating that the sole appellant has expired, but in spite of that, no petition for substitution has been filed. Accordingly, the first appeal stands abated. The sole appellant was there. Now the appeal was admitted. This is the difference. The appeal was admitted. Now there is a provision under Order 41 Rule 17 and 19, which says if appeal has been admitted, then it should be for readmission. There is a petition under Order 19. They have not filed that petition. Therefore, office has pointed out to correct the provision of law. They have filed a petition, IA, last order your lordship may kindly see. The IA they have filed and correcting the provision of law. That provision of law is not applicable, but your lordship has conditionally allowed that petition subject to objection raised. By your lordship's order, I think my lord is
That's
not.
right. So you are raising the
I am
objection
raising
now.
the petition because this law.
They can still correct the provision of law. What's the
Of
big
course
deal
they
about
can.
it?
But this because my lord, my consideration is the.
Are you serious about this
Yes, I am
objection?
serious because this is the Article 215 of the Constitution Court of Record. High Court is a court of record. Therefore, let them correct that provision. Otherwise, it is.
So before you file your reply, take care of whatever he is
Yes,
saying.
because it has a
If you-
different sequence.
Verification, your lordship will take judicial notice. He is a party to the list and he has filed wakalatnama with some lawyer. He is still appearing. His interest is there. I am not disputing.
Who is a party to the list?
Yes, he is a party to the present case.
One of the party, other counsel I can represent as a counsel, other respondent.
It's a personal matter.
The provision has not been pointed out by the office.
Need not be.
They are not.
Council can always point
Yes.
out.
Your lordship will take.
Is what's the big deal about it? If you want to
Sheer
see,
technicalities.
Mr. Dilip, please appreciate. If he has any objection regarding provision of law, do you have any serious objection in correcting, or you want to insist that it is the provision of law?
We will do it.
You do it, but you have to file a petition to that effect. Therefore, when you are filing the reply, do the needful. You just reserve your right to correct the provision of law. उसके अलावा भी कोई objection है? Mediation नहीं होगा क्या इसमें? आप लोग आपस में लड़ रहे हैं? Is there any possibility of mediation?
सब कुछ संभव है.
Is there any possibility of mediation?
इनके तरफ से क्या होगा I don't know. मेरे तरफ से सब कुछ.
It's a land dispute.
His cross appeal has been sent back to the court below.
I just want to know if the parties are willing for mediation, we'll
Yeah.
take care of everything.
Yes, yes, yes.
You are willing for mediation? Do you have any instructions on this?
Yes, lordship, sometime maybe, you know.
Next week may you just let us know. Next week may you please let us know if you want to go for mediation.
I am here to. There is no problem.
I'll tell you one thing.
Specific
The
for
most
one,
peace-loving people are the advocates. When an advocate is a party to a litigation, I have all trust that it can be settled through mediation. The value of peace is maximum, they can really appreciate the value of peace.
Value is a level like 79,000 did in his favor, suit for a specific performance.
No, whatever. You want to, please go for mediation. If you want to, we want to settle these kind of litigations. What's the big deal about it? You seek instructions, right? Counsel for the parties submit that they shall also seek instructions as to whether they are ready to settle the dispute, to settle all disputes between the parties through mediation. सारा जितना भी है सब.
उसने ये खाली पैसे का है, ये कहते हैं 11 लाख, हम कहते हैं 5 लाख, यही फर्क है.
कहीं तो मिडवे होगा ना. अब तो वैल्यू अप्रिशिएट कर गया होगा, चाहे कुछ भी डेप्रिशिएट कर दिया होगा, व्हाटएवर. लैंड का वैल्यू तो डेप्रिशिएट करता नहीं.
वैल्यू का स्पेसिफिक रिलीफ इनका किया है, इनको रिफंड करना है हमको मनी with 6% interest.
Please figure it out. Please figure it out. I am sure it can be settled.
क्या नहीं हो सकता.
Mr. Srivastava, इससे बढ़िया क्या हो सकता है?
हम तो इसी के लिए आए हैं कि भाई करना चाहे तो कर सकते हैं, तो आई एम रेडी टू फेस द लिटिगेशन. वो
आप तैयार हैं मीडिएशन के लिए? ये तैयार.
हमारा खुद
आप लोग प्रपोजल लेके आइए, यहीं से ऑर्डर ड्रॉ करेंगे.
इनके चाहेंगे कि नहीं, आई थिंक आई हैव अ डाउट.
चाहेंगे, ऐसा डाउट में मत रहिए. The worst of the litigants are settled through mediation.
Yes. What mediators are there.
अब तो कानून भी बना दिए हैं, फर्स्ट गो फॉर mediation.
आज हम लोग डीबी में एक मैटर डिस्पोजल किए हैं, 4 केस सेटल थ्रू मीडिएशन. So it is quite possible. Tell you next. डेट नेक्स्ट फ्राइडे को रहेगा. मैटर कोशिश करिए भाई, कितना लड़िएगा.
हम कहाँ पीछे हट रहे हैं.
जीवन खत्म हो जाएगा ऐसे ही लड़ते लड़ते, और जमीन यहीं रह जाने वाली है.
नहीं, जमीन का मसला ही नहीं, खाली पैसे का मसला है.
तो पैसा भी यहीं रहने वाला है.
पैसा भी नहीं रहता है. अभी तो 3 करोड़ कितना पकड़ाया.
Item 7, CMP 717 of 2019.
Yes, please. Who is appearing? Yes, tell me, what do you want? Restoration. I know, what a mess.
Restoration of restoration. CMP 300.
Service is complete?
Service complete. Service complete.
Okay, पहले रेस्टोर कर दे.
इसमें एक लिमिटेशन पिटीशन है 136.
कितना? How many days?
136.
रेस्टोर कर देते हैं, रेस्टोरेशन में लड़िएगा. Right? This is an application for
restoration of a CMP.
Restoration. It was dismissed for non-appearance or non-removal of defects.
Non-compliance.
छोड़िए, नहीं आया तो हम लोग क्या कर सकते हैं.
Part 3 onwards will be the discussion.
Okay, लिखिए. CAP number 717 of 2019. Counsel for the parties are present. Counsel for the petitioner submits that the present petition has been filed for restoration of CMP number 318 of 2017. 318 of 2007, which stood dismissed for default on account of non-compliance of order dated 7/4/2019 on due to non-service of notice in the office of Learned Advocate General, Jharkhand High Court Ranchi within the stipulated time. The Learned Counsel submits that the order could not be complied due to bona fide mistake. कहाँ लिखे हैं? He has referred to paragraph number 4 and 5 of the 4, 5 and 6 of the petition for restoration. The learned counsel for the opposite parties.
No, not for all the opposite parties. The state is also there, Mr. Franklin.
Yes.
Opposite party number 39 and 40. No.
Appearance दे दीजिए. The learned counsels who are appearing for the opposite parties or who are appearing on behalf of the concerned opposite parties have no serious objection to the prayer for restoration. After hearing the counsel for the parties and after being satisfied with the cause shown by the petitioner, regarding non-compliance of order dated 5/4/2019, passed in CMP number 318 of 2017. This petition is allowed, and CMP number 318 of 2007 is restored to its original file. Let CMP number 318 of 2007 be listed on post-vacation couple paper. आइए कौन सा आइए तो सब्स्टिट्यूशन अलाउ हो चुका है ना?
उसमें नोटिस भी वो
आइए पेंडिंग है क्या?
पेंडिंग
लिमिटेशन पे एक है, आगे का एक डिवीजन ऑफ पार्टी
वो ऑर्डर कर दे. आइए नंबर 4522 of 22 डिले का नोट कर दीजिए. हाउ मेनी डेज? 136 days. And then 3396 of 22. This is for condonation of, this is for deletion of party.
8440 of 22.
8440 of 22. This petition has been filed for what is it? What language have you written? I'm not able to make out head or tail of it. What do you want? Who are to be deleted? Mr. Mehta, I'm asking you.
No.
What is your petition? Tell us, what is your petition?
Memo was written due to non incorporation of the parties. Some particular left.
What is your prayer in this petition?
So it was withdrawn and thereafter the CMP was filed.
I am not able to get it. What prayer have you made in this interlocutory application? What is your prayer in this interlocutory application?
Present CMP for the region stated that the office memo with regard to dismiss for default on 10/2019 of CMP 3 was given to the learned advocate of the petitioner on 7/5/2019. Then after informing the party after opening the court after summer vacation, the present
No, no, IA number 8440 of 2022.
I number
8440 of 2022. Mr. Mehta, you are not aware about your records. क्या होगा इस litigant का? This litigant will perish because of you. Yes, tell us.
8440.
Yes. Under Order 22, Rule 4 and Section 151 of CPC.
Yes.
What is your prayer?
Substitution है इस बीच में जो लोग घटित हुआ
For deleting whom? Which petitioners or respondents you want to delete?
Here I am stated that the CMP
You just tell me the petitioner number or the respondent number you want to be deleted.
for 3 onwards, OP2 Kunubala Devi died and hence her name may be deleted from the cause title. Her heirs are already on record. That heirs of OP number 15 and 38 may be substituted as follows. These are the 15A, B, C, and then after 15D, 38A, 38 and 15.
Okay. Notices were issued to them.
Yes, Lordship. And in filing this petition, there are some delay.
You forget it. You just tell us what is OP number 16, 36 and 41?
OP number
16, 36 and 41.
Musamman Santa Devya, wife of late Mohit Chandra.
Notices have gone to them also?
Yes.
Okay.
And thereafter reported that
Who is for 41? Who is appearing for 41? Nobody.
about 41.
Plus 41 is the secretary Chandipur
Yes.
Master B Cooperative Society.
For his behalf, state has appeared.
We have filed a counter on the 39 40. We will represent it.
41 also.
Yes, we do appear for cooperative society.
Okay, what's your name? Neil Abhijit Tuk. Give your memo of appearance. Neil Abhijit Tokpo appears for secretary Must GB Cooperative Society, Chandipur Village. Right?
Yes, sir.
Okay.
39, 40 and 41.
39, 40 and 41.
This should state.
Okay. IA number 8440 of 2022. Counsel for the petitioner seeks deletion of OP number 2, who is said to have died, by stating that her heirs are already on record. Counsel for the respondents have no objection to the prayer. Accordingly, the petitioner is permitted to delete opposite party number 2, the name of opposite party number 2 from the cause title. So far as the prayer for substitution of OP number 15 and 38 and 15 and 38 is concerned, the same is allowed. That has been allowed earlier, no?
Earlier perhaps, because notice they have appeared also. Notice
Okay.
gone to the substituted.
All right. The same is hereby allowed, right? You have done substituted service.
No.
The petitioner has already undertaken has already complied with the order for substituted service of notice, and an affidavit to that effect has been filed before this court by the affidavit dated 10/4/23. Where is the substituted notice? Have you filed it?
Yes, ma'am.
Paper publication?
Okay.
Where is that?
I have also supplemented to that effect.
Tell us, where did you find it?
And in original I have filed it.
Where is it?
But that was
You must have filed it with some filing slip, no?
Yes.
What is the filing number? Mr. Mehta, it is very difficult to deal with your cases. You are not aware about your own records. Where is the filing number? Where is the filing number? Mr. Mehta, where is the filing of your newspaper? How many years do you need to rectify your records? Where is the newspaper? दिखाइए जरा भी इनको, कुछ ऑर्डर मत करिएगा, 6 महीना के लिए एडजर्न कर देना। क्या कर देते हैं? You just show it from the records that you have filed it. Repeatedly I have been telling you that you don't see your records. So you keep it with you.
No, I have filed it.
Show it to us. Please show me the filing receipt. You just can't say that you have filed it unless you show me the filing receipt. सब delete कर दीजिए. At the request of the counsel for the petitioner, post this case on 15th of March, 24. No, next week. I can't waste time like this. For half an hour, we are struggling with your petitions. A petition which is not making any sense. We are trying to figure out what sense can it make to help you out. And you are not aware about your petitions. You don't comply with the court's order. Why should we bother about you?
I to meet CNP 1220 of 2023.
Yes, petitioner.
In this case, Lordship, IN number 10598 of 2023 has been filed for condonation of delay of 384 days in filing this restoration application.
Has any such delay was pointed out by the office?
Yes.
Why? Under 226?
Lordship, may I receive Lord, therefore, Lord, this petition has been filed.
The petition was under 226?
Lordship.
Your Worship, it was dismissed for default.
The matter relates
That's right,
to restoration of land under section 71 of the CNT Act, which was dismissed on account of non-compliance of the pre-emptory order passed by the Honorable Court. Thereafter, my Lord has passed an order on 6/10/2023 in CMP number 593 of 2002, restoring, my Lord, WPC number
Yes.
2161 of 2014, with some direction, my Lord. Order, Lordship may kindly see, my Lord, page annexure 1 is the order at page 11.
This is CMP number 18 of
Lordship, 2021.
2021.
Lordship,
This has been allowed.
allowed subject to the condition that the petitioner would remove the surviving defects in the REIT records by 8/9/2002.
Okay.
And the petitioner should deposit cost of rupees 5,000 in Jharkhand State Legal Services Authority.
That was complied.
Yes, Lordship. I have complied this part of the order, but all defects, my Lord, could not be removed within the stipulated time. Because, my Lord, certified copy of the order was not available, therefore it could not be filed within the stipulated time. Then, my Lord, I have filed another CMP.
Again, this is for default because of non-compliance with the order.
Liberty was given, Lordship may kindly see annexure 2 at page 30.
So that was not complied, Your Worship. Then that is
No, all defects have been removed. I have stated in my petition that all defects have been removed. Inadvertently, my Lord, CMP number 593 of 2022 was filed, which was ultimately withdrawn. Please liberty to file fresh petition. That has been filed. And I have stated in my petition that all defects have been removed. Lordship may kindly see para 8, Lordship. Page internal page 7. All defects.
All the defects in which record?
In CMP number 18 of 2021.
To CMP number 18 of 2081.
All defects pursuant to the order passed in CMP number 18 of 2021.
This is so misfortune of this High Court that so many restoration petitions are being filed. And restoration square, cube, quadruplicate.
This is my fault, Lord. This is my fault. Certified copy of impugned order was not available. Therefore, Lord, it could not be filed within the SPA.
Which certified copy was not available?
Certified copy of the order passed by the special officer, scheduled areas regulation Ranchi, restoring the land under section 71 of.
What prayer have you made? Restoration of CMP. You want only restoration of CMP 18?
Then, my Lord, my lead petition will be restored.
Where is order dated 5/8/22? This one.
Annexure 1, Lord, page 11.
Counsel for the parties are present.
Your Worship, notice has to be sent to the private respondents.
You are representing.
Are you not representing them?
Your Worship, I will, Your Worship, because once it reaches them, their partners.
What do you mean once it reaches them? You hold wakalatnama for them in CMP or not?
Your Worship,
In CMP number 18 of 21, do you hold wakalatnama for them or not? You are holding wakalatnama for them? Yes or not?
Your Worship, we will.
Why are you standing if you don't have wakalatnama? Yes? Why are you standing if you don't have wakalatnama? Are you holding wakalatnama for these persons in CMP number 18 of 21 or not?
Your Worship, in the main writ we are holding.
In the main writ petition you are holding? In CMP number 18 of 21 also you are holding? That should be sufficient. They are arising out of the same proceedings. Then?
Sorry to interrupt. Here the new CMP,
That was also disposed of because of non-compliance.
Anyways, CAP number 1220 of 2023, counsel for the petitioner submits that this petition has been filed for restoration of CMP number 18 of 2021, which has been dismissed on account of non-compliance of order dated 5/8/2022. Counsel for the petitioner has submitted that the order dated 5/8/2020 that cost pursuant to order dated 5/8/2022 was in CMP number 18 of 2021 has been deposited, but due to bona fide mistake, the remaining defects could not be removed within the stipulated time. And as such, CMP number 593 of 2022 was filed before this court for extension of 4 weeks' time to comply the order passed in CMP number 18 of 2022.
2021.
18 of 2021. However, CMP number 593 of 2022 has been permitted to be withdrawn by terms of order dated 6/10/2023 with the liberty to file a fresh miscellaneous petition, and consequently the present petition has been filed. Naam bataye? Mr. Faisal Alam for the private respondents advocate submits that he is the counsel for the private respondents in the writ petition also. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances of this case, the CMP number, the present CMP is allowed, and the CMP number 18 of 2021 is restored to its original file. Need not be. You are already representing the writ. Ultimately, it is a writ which will be restored, isn't it?
मेरा हाथ में था मैं
क्या?
मेरा हाथ में ही था मैं करने It was on my hand. I am sorry.
What your hand?
ये जो फाइलिंग किए हैं नोटिस
अब देखेंगे बाद में।
यही पर है
नहीं, अब अदर साइड भी नहीं है। इतना आपका इतना हॉचपॉच है, आप बताइए ना। People are dying and you are not able to restore a case. Just imagine. Yes. I just can't do it. No. Where is the original newspaper?
Yes, वहाँ भी है हम निकाल ओरिजिनल जो ऑर्डर है अकॉर्डिंग
No, get hold of the other side, then only I will pass the order. I will not pass the order.
आगे केस हो जाए लिमिटेशन प्रीवियस वाला केस
हाँ
आगे लिमिटेशन पास
हाँ डिले कर लो
Item 9 already adjourned. Item 10 CMP 208 of 2023.
Lordship, this petition is filed for restoration of the case number 26/19.
Who is for the respondents? Counsel for the petitioner is present. Nobody appears on behalf of the respondents. This petition has been filed for restoration of WPS number 2617 of 2019, which stood dismissed on account of non-compliance of order dated 11/11/2022, passed by this court. The learned counsel for the petitioner has submitted that when the case was called that the day when the case was listed, the list could not be marked, and therefore the petitioner was unaware about the order dated 21/10/2022 passed in the writ petition. Nobody has appeared on behalf of the respondents to oppose the prayer. No counter affidavit as such has been filed to this petition. After hearing the counsel for the petitioner and after being satisfied with the cause shown for non-removal of defect within the stipulated time, the present CMP is allowed and WPS number 2617 of 2019 is restored to its original file. Office is directed to place the writ petition before appropriate bench as per in the month of January 2024.
Item 11, CMP 711 of 2023.
Your ladyship, there was a direction for filing of the supplementary affidavit for amending the name. It has not been filed, but it is being ready.
Ready means what?
For the
Why
file.
have we not filed it for so many
Your Lordship,
dates?
we have communicated to the petitioner due to some difficulty he couldn't come. He came and it is being ready. The name, your ladyship has asked for the name of the application and all. It is mentioned in this.
CMP number 711 of 23. You are filing it right now?
Yes, your ladyship.
Have you got a copy?
Yes, yes.
A supplementary affidavit is being filed on behalf of the petitioner is taken on record.
Para number 6. 5 and 6.
Counsel for the parties are present. This petition has been filed for restoration of WPS number 7701 of 2011, which stood dismissed on 11/10/2022 on account of non-prosecution. The learned counsel for the petitioner has referred to paragraph 4, 5 and 6 of the supplementary affidavit which has been filed today. Counsel for the respondents has no serious objection to the prayer for restoration after hearing the learned counsel for the parties and being satisfied with the cause shown by the petitioner for non-appearance on 11/10/2022. WPS number, this petition is allowed and WPS number 7701 of 2011 is restored to its original file. Office is directed to place the writ petition before appropriate bench as per roster in the month of January 24.
Notified case under heading for Lok Adalat item 1, CMP 878 of 2023.
CMP number 878 of 23. Ms. Swati Salim, Associate Counsel of Mr. Amit Kumar Das, has submitted that this case has been listed at her instance so that the matter can be referred to Lok Adalat, which is scheduled to be held tomorrow. She submits that unfortunately the advocate of the petitioner has expired, but the respondents have contacted the petitioner, who has expressed her willingness to come to this court in the Lok Adalat to be held tomorrow, to accept the payment being offered by the respondent. By making this submission, she submits that the matter be referred to Lok Adalat. Considering the aforesaid submission, let this matter be placed before Lok Adalat. इसको जाइए, इसको साइन करना है अभी, लेकर आइए.
From day list item 12, CMPU 712 of 2023.
Yes.
Due to non-compliance of the order number 16 May 2023, one time copy has not been filed. Page number 36, Lordship.
That was the only defect.
Yes, Lordship.
Page number 36.
Yes, Member. There is some handwritten part of the on the map, so I could not find. There is the map.
Okay, so you want that defect to be ignored. Page number 36.
Yes, Lordship. It may be.
No, for that matter, you have to make a prayer when the writ is restored. Right. CMP number 712 of 23. The learned counsel for the petitioner has submitted. This petition has been filed for restoration of WPC number 2095 of 23, which stood dismissed on 16/6/2023 for non-compliance of order dated 16/5/2023. The learned counsel has submitted that the only surviving defect was in connection with page number 36 of the writ petition, a typed copy of which could not be filed. The learned counsel submits that the page number 36 considering the fact that the page number 30, the learned counsel submits that if the writ petition is restored, he would make a prayer for ignoring that defect in connection with page number 36. The learned counsel for the opposite party has no serious objection to the prayer for restoration after hearing the counsel for the parties and considering the aforesaid facts and circumstances. The writ petition, this petition is allowed and WPC number 2095 of 23 is restored to its original file. Office is directed to place the aforesaid writ petition before appropriate bench as per instructed in the month of. ये मेरे को, is it connected? It is an assigned matter. In the month of January 24.
Item 13, CMP 1121 of 2023.
Lordship, this applications for restoration of the writ petitions, Lordship, this are dismissed for default for non-appearance and non-compliance to the order, that is the defect in words. This is only 5 para is 15 to 9. Lordship, but never interest, lose the interest. This is the appointment of the compassionate appointment. And immediately he engaged the another.
Who was the previous counsel? Who was the previous counsel? What happened? Why didn't you appear? Why did you not remove the defects?
I asked him, he already, I already asked him regarding maybe the fees matter, I don't know everything is clear now. So I can't comment on this.
Why didn't the council appear on 6/6/2022? Yes? Tell me, who was the council? Ranjan Kumar. Why he did not appear? And the application is being filed by somebody else. Why are you silent about it?
Lordship, sir, I can't comment on this because this is the matter of personal, I think so. Maybe the one advocate can't commit the other advocates.
Then we will impose some cost.
That's the reason.
Then we will impose some cost. We do not know. You realize it from the other advocate who did not appear. Right?
No, Lordship, because.
Then what?
Because this is a matter of the.
You see, because of negligence of one advocate, the case is dismissed for default. Another advocate will come and say that he does not know as to why he did not appear. Right? Then I will impose some cost on you and you realize it from the concerned advocate who did not appear.
Maybe my experience is little, that's the reason, maybe, because of my enrollment is 2019. So hope so I couldn't understand exactly want to me from the information regarding this.
You see, we restore the case by seeing good reasons for non-appearance. Right?
Yes.
There is no explanation for non-appearance.
Non-appearance of the advocate.
That's right.
That's I get the brief from my client. He told there is nothing. This is the duty of the advocates to remove the defect, and only the reason the not removing the defects, and that I got the brief. And this is a matter of the compassionate appointment, and thus I am here.
Your client might not have given the fees to the council. Otherwise, why would the council not appear? Tell us.
But I got the fees also.
You must have got the fees to get a case like this restored.
No,
Then
I will remove I give the undertaking this court.
earlier also this case was dismissed for default.
Yes,
The death of your father is in the year 1981. You expect compassionate appointment?
not only the compassionate appointment, Lordship, this is a matter also of the retirement benefit also. That's the reason.
The counsel for the petitioner is present. The learned counsel for the petitioner has submitted that. This petition has been filed for restoration of WPS number 5293 of 2017, which stood dismissed on account of non-appearance of the then counsel on account of non-removal of defects. The learned counsel submits that after the dismissal of the case, the matter has been handed over to him and he is not aware as to why the earlier counsel did not take steps to remove the surviving defects. He submits that the matter relates to compassionate appointment and the father of the petitioner had expired in the year 1981. And apart from that, the petitioner is also claiming the death comitarial benefits. Order dated 6/6/2022, passed in WPS number 5293 of 2017, is quoted as under. From the perusal of the same, it appears that the writ petition was earlier also dismissed for default and was restored, and after restoration it was again dismissed on account of non-removal of defects. However, considering the submissions made by the counsel for the petitioner, the WPS number 5293 of 2017 is the present CMP is allowed, and WPS number 5293 of 2017 is restored to its original file, subject to deposit of a cost of ₹5,000 before the High Court Legal Services Committee. A receipt of the deposit be filed in the registry by next Thursday.
Item 14, BA 8427 of 2023, along with item 15.
Yes, there are two bail matters.
Yes, ma'am, the co-accused will come out, that's why this has been listed for the
No, why two cases? Counter affidavit has been filed in both the cases.
There
What
are
is the
zero
stage of
double
the
zero.
case? What is the stage of the case?
What is the
Let us
case?
see the first delete method.
Yes. What is the earlier?
What is the counter affidavit? Let us just have a look at it.
Something is that in para 40 of the case diary, it has come that upon the confession of the co-accused, this petitioner's name has flashed. That this petitioner was in the said village, coming from the said village, and he was having money. So these accused persons sought the money, and they planned to loot the money, and they killed him.
What's the confession? On whose confession have been made accused Karma and they have been granted bail matters. On the basis of the confessional statement of Badal
Who has
Khadiya,
granted bail?
Badal Khadiya and Karma.
No, who has granted bail? Where is the bail order?
Annexure 2 and 3 months.
What is the stage of the case? What?
Framing of charge.
Framing of charge.
The accused persons on whose confession the petitioner has been made accused, they have been granted bail matters. This is the first information report was lost.
Where is the earlier order of rejection?
It was not rejected by the ministry.
Okay.
For the first time it has come.
For the first time.
Yes.
Both the cases.
Yes. Yes. Since the co-accused has been allowed bail by your lordship, that's why it has been placed for your lordship.
Where is the order by which the bail was granted? Where
Page
is
14 and except 12. Page 14 and except 2.
the confession statement was of Karma Ora?
Yes, Lords.
Is that correct? Both of you?
That has already mentioned in the case diary also.
And Karma Ora, both.
Raju Gop and Karma Rao.
Badal Khadiya
Badal
and
Khadiya
Karma.
also, para 42 of the case diary.
FIR is against unknown?
Unknown. As per the case of the prosecution, the deceased left the house, thereafter didn't return and subsequently returned.
Okay. Learned counsel for the parties are present. Custody बताइए, delete method.
26th July 2023,
26/7.
2023.
Any antecedent?
No.
Both of you?
Yes, that is already my 7th.
In the counter affidavit is no mention.
No, no, you should be knowing your antecedent.
No antecedent, no antecedent.
पहले BA नंबर 8427 of 23 लिखिएगा, है ना? अपीयरेंस रिकॉर्ड करिए. कस्टडी बताइए.
26 July 2023.
Okay. The counsel for the petitioner submits that the petitioner is in custody since 26/7/2023 in connection with Gumla PS case number 41 of 2019 dated 14/2/2019 corresponding to GR case number 316 of 2019 for alleged offence under section 302 and 34 of Indian Penal Code. The learned counsel submits that the FIR is against unknown and the name of the petitioner has come up during investigation in the confession statement of co-accused. The learned counsel has also submitted that the co-accused have been enlarged on bail. Counsel further submits that so far as the stage is concerned, it is at the stage of framing of charge. The counsel has also submitted that the petitioner has no criminal antecedents. Counsel for the opposite party has opposed the prayer, but the submissions made by the petitioner, by the counsel for the petitioner, are not in dispute. After hearing the counsel for the parties and considering the fact that the co-accused have already been enlarged on bail by this court in BA number 5879 of 2019 on 14/8/2019 and also कुछ और को भी तो मिला है and also in BA number 5654 of 2019 on 5/9/2019 the petitioner is directed to be released on bail subject to the condition that he would attend the वही हम लोग का जो रेगुलर कंडीशंस होता है एंड ही शैल नॉट लीव द पुलिस स्टेशन. आप ही के पुलिस स्टेशन में ऑफेंस है, दूसरे पुलिस स्टेशन में
कोर्ट में अपीयर करेंगे ना. द इन्वेस्टिगेशन देयर इज नो नेसेसिटी फॉर गोइंग कोर्ट में अपीयर करेंगे नीचे रिप्रेजेंटेटिव फिजिकली.
भाग में तो जाते हैं ना.
नहीं
ही शैल नॉट लीव द गुमला पुलिस द एरिया अंडर गुमला पुलिस स्टेशन विदाउट prior intimation to the concerned court.
Same case is the next case.
ठीक है, सेम ऑर्डर कर दीजिए.
Yes, same.
ठीक है, इसमें भी ये तो 82-83 के बाद आप अपीयर हुए हैं. हाँ,
इसमें EVP जब रिजेक्ट हुआ था उसके बाद फाइनल फॉर्म सबमिट हुआ था.
अच्छा,
फाइनल फॉर्म सबमिट के बाद फिर ये कॉन्विडेंस हुआ.
it is arising out of same FIR,
सेम FIR
same impugned order also. Everything is the same.
impugned order is different.
इसमें काउंटर एफिडेविट में क्या दिए आप? कोई क्रिमिनल एंटीसीडेंट नहीं है आपका?
हाँ, कोई एंटीसीडेंट नहीं. पैरा 3 में आया काउंटर का कोई एंटीसीडेंट है. अभी कुछ हम लोग नहीं है.
फ्रेमिंग ऑफ चार्ज 8/12 को है.
हाँ, आज ही पे रखा हुआ है.
हो गया आज?
नहीं पूछा.
चलिए सेम ऑर्डर कर दीजिए. आधार वाधार अपना दे दीजिएगा और भागिएगा मत.
for hearing. Item 16, essay 110 of 2017.
Present second appeal filed by the plaintiff, suit was decreed and appeal has been reversed.
Okay.
Appellate court has been reversed.
What are the questions of law?
Suit Your Worship was for declaration of title over a strip of land measuring 14 feet 6 inches and 24 feet 6 inches with brick compound wall.
What is a question of law?
Yes. One of the question of law which arises in this particular case.
Where have you framed the question of law? Where have you framed the question of law? कहाँ है आपका क्वेश्चन ऑफ लॉ? तो ग्राउंड्स है फॉलोइंग सब्सटेंशियल क्वेश्चन ऑफ लॉ. कितना लंबा लंबा सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है, क्या है? नो यू फ्रेम द क्वेश्चन. ये कोई क्वेश्चन ऑफ लॉ है, नरेशन है ये तो.
इसमें क्वेश्चन ऑफ लॉ ये है कि ऑर्डर 41 रूल 31 ऑफ कोड ऑफ सिविल प्रोसीजर
आप लिख के लेके आइए, ऐसे नहीं चाहिए. Second appeal number 110 of 2017. Counsel for the petitioner prays for time to reframe the substantial question of law involved in the present case. Please, next week rख दें. Pose this case on next Friday. Reframe कर दीजिए.
इसमें पॉइंट ऑफ लॉ एकदम अपैरेंट है. पॉइंट ऑफ लॉ ये है कि ऑर्डर 41 रूल 31 का मैंडेट है. The appellate court will frame point of determination.
नहीं determine determination.
It has not been framed. And apart from that, the reasoning assigned for the trial court has decreed the suit on the ground of after perusal of entire materials available on record and documentary evidence, oral evidence.
The appellate court, while reversing the finding, has not discussed the trial court's order.
Not discussed the evidence, oral evidence at all, and had no point of determination has
So
been
it is a matter of remand to the first appellate court.
But the point has to be framed.
That's right. Substantial question will be framed. भाई आप लेके आते हैं, हम तुरंत कर देते हैं. इसको क्या करना था? एडमिट करते, नोटिस करते, रिकॉर्ड मंगाते, कर देते. नहीं आप लेके आइए. आप लेके आइए, नेक्स्ट वीक कर देंगे. अदर साइड अपीयर नहीं हो रहा है? हाँ, एडमिट होने के बाद ही.
हियरिंग नहीं चल रहा.
नहीं, ये तो ऑर्डर 41 रूल 11 है, तो एडमिशन ही है ये.
एडमिट हो गई उसकी बात ही.
ये असाइंड है.
इसमें दो लीडर कमिश्नर
आई अप्रिशिएट दैट. ये एक सेकंड, इतना बार तो आप लोग इतना बार से तो एब्सेंट ही चल रहा है. ठीक है ना? कंटिन्यूअसली आप एब्सेंट हैं. आज आपको अचानक अर्जेंसी हो गया है कि कर देते हैं इसको. आप रीफ्रेम करिए क्वेश्चन अपना. कंटिन्यूअस एब्सेंट है. और ऐसा केस में अगर रेस्टोरेशन फाइल होने लग जाए तो समझ जाइए क्या होने वाला है. सब गिरिडीह का पार्टी लगता है, एक ही परिवार के हैं, सब एक ही फैमिली के हैं रिस्पोंडेंट्स.
नो, रिस्पोंडेंट्स एक फैमिली के हैं.
हाँ, तब तो सर्विस होने में भी दिक्कत नहीं होगा.
रिस्पोंडेंट्स एक फैमिली के हैं, लेकिन अपीलेंट तो पार्टनरशिप फॉर्म है.
तो अपीलेंट का बात दूसरा है. इट डजंट मेक एनी डिफरेंस. आप रीफ्रेम करके लाइए. और ये क्या केस हमारे पास असाइंड है? तो फिर वही बस नोटिस सर्व होगा, आप हियरिंग के लिए तैयार हो जाइएगा. एलसीआर मंगा लेंगे. एलसीआर तो मंगाना पड़ेगा ना. ठीक है, आप नेक्स्ट वीक आइए. पहले से भेजिएगा क्वेश्चन ऑफ लॉ, फ्राइडे को दे दीजिएगा.